Several years ago, I was appointed by the Supreme Court of Kentucky to the Rules Committee for the Supreme Court. And what the Rules Committee does is it gets together and figures out what rules need to be added to the Kentucky Rules of Civil Procedure, and then we recommend them to the Supreme Court. And if the Supreme Court agrees with our rules, then they are enacted by the Supreme Court and they become the new Rules of Civil Procedure. One of the rules I worked on was this rule, which is Kentucky Rule of Civil Procedure 7.03. And Kentucky was kind of behind. By the time we did Rule 7.03, the feds had already done a rule on privacy information. And this rule and the federal rule, which I'll get to next, and also the bankruptcy rule, are all very similar. And what they do is they prohibit parties and lawyers from filing documents in court that have certain information in them. And this information has to be redacted. The information that you're prohibited from filing in court are the Social Security number. It has to be redacted so that just 4 digits show. A financial account number, so your loan number has to be redacted so that just 4 digits show. The birth date of a borrower or any party to a litigation has to be redacted so that a birth date is not on there. And the federal rule and the bankruptcy rule, which I'll get to later, also require the names of minor children to be redacted so that you can only put initials of minor children in documents. Their full names cannot be in documents. And these rules, like the Kentucky one, have a provision that says if an attorney or a party fails to redact the documents appropriately, they can be sanctioned by the court. So we're talking about 3 things here. We've talked about rules, and next, and the federal rule looks pretty much like the Kentucky rule. It's Federal Rule Procedure 5.2. Requires redacted filings. The same sort of information has to be redacted. And then bankruptcy rule 9037 has the same requirements for redacting. The same sort of information has to be redacted by filings with bankruptcy court. Now these are the rules. We've got 3 R's we're going to talk about: rules, reasons, and risks. What are the reasons for these rules? Well, the reasons for the rules are 30 years ago when Liz Thompson was filing complaints at Fayette Circuit Court for every bank in town. I would draft a complaint, right? Print it out on my IBM Selectric. Anybody in here that old? We would print it out on this electric, and we would attach a copy of your contract to it, right? A complaint's going to have a copy of the contract attached, and a copy of your account statement to show what your balance was, probably attached. If you had security, we'd attach a copy of the mortgage. If you had a mortgage or if you had a lien on some kind of personal property, we might attach the security agreement or the retail installment contract, and then we'd attach your UCC filing maybe. And we would file all that over in Fayette Circuit Court. Well, what if somebody wanted to look at that filing? What would they have to do? They'd have to walk into Fayette Circuit Court. They'd have to go see Bobby True, who was the clerk at the time. Very, very crotchety old guy. And if they could get past Bobby True, they might be able to look at that court file. You know, some bum off the street, or if 300 people, or if somebody came in and wanted to see 100 court files, they would never have been able to do that. Bobby True wouldn't have given them those court files. They were public records, but he would have got a little worried if somebody who was not a lawyer, not involved in any of the litigations, was in there trying to look at 100 court files. He would have called the police, I'm sure. So that was then. and this is now. And what do we have now? Now we have electronic filing, ECF filing. So this started a long time ago in federal court first. We started filing electronically our pleadings in federal court, and then we filed them electronically in bankruptcy court. And now, by the end of this year, 2015, the state of Kentucky, every circuit court in this state will be filing pleadings electronically. Okay? So that's, we're in the future now. So what happens when all these pleadings are filed electronically? Anyone who has a PACER ID number for federal can go on and see any federal record. So what would happen if all those documents I've talked about, with all those numbers, when I filed those suits in the 80s and 90s, they had your whole account number on them. They had the whole Social Security number of your borrower on them. They had their addresses. They had everything. If we filed that electronically now, there would be companies out there mining that information to steal people's credit identities. And that's what would happen. And that's why these rules had to be enacted, because if they hadn't been enacted, that's what we'd be. We'd have companies out there in China, probably, in Russia, just mining our PACER data and getting all this information and then stealing people's identities and filing all these reports. So there are good reasons for these rules, but now we have to comply with them. I used to specifically put a full Social Security number on every garnishment so I wouldn't garnish the wrong family member's account, right? Because dad and son and uncle might have the same name in Pike County. Those days are gone. We cannot do business that way. We have to watch the privacy information. So what are the risks? I don't have it in a slide, but I have given you some cases. I've given you 3 cases. And the problem with my cases is that these rules are fairly new, and so there's not a lot of case law under them. There's a case, the Good case, which is a 10th Circuit case, and in that case, the plaintiff filed pleadings which had attached to them the alien registration of a Japanese American person. And that alien registration had all of her family information in it, just very complete family information. Because that party did that, and there was a local rule against it at the time. These rules had not been enacted, but there was a local rule. The Japanese American, Ms. Good, sued the party who filed those pleadings for having done that. And what the Good case said, what the 10th Circuit held, and this has been cited again and again in later cases, was that there is no private right of action under a rule, civil rule of procedure, that there's no private right of action, so that they could not bring a claim in court and seek damages for having violated this rule. So that's the first case. But now that case was before these particular rules were enacted. It was just a local rule at the time of the court that this lady was in front of. The next case I have for you is a case that's a bankruptcy case out of Arkansas, and it's called Gestvang. Gestvang. Boy, that's a good name. Gestvang. In that case, and this is a theme that comes up for bankers across the United States. But in this case, Green Tree Financial, who I used to do a lot of work for, they used to finance mobile homes all over the United States and a lot in eastern Kentucky. Green Tree Financial filed proofs of claims with Social Security numbers on them, which, was a no-no. This was in 2009 when this case came down, by then they should have known better. But they filed proofs of claims, and so they were violating this bankruptcy rule 9037. So they violated bankruptcy rule 9037 by filing these proofs of claims. And they sought sanctions from the court. And they wanted their attorney fees paid, they wanted sanctions. And the court in that case looked into it and found that there was not bad faith, and the bankruptcy court refused to grant sanctions. But I don't think this is going to happen in the future. Just Bang was also a little before this rule, and I think that now that this bankruptcy rule is in place, I think there will be sanctions. The court specifically looked in Just Bang to see if there was any bad faith, and they said the attorney had done it innocently, the party had done it innocently, there wasn't any bad faith, and so it declined to grant sanctions. But I don't think that's going to be the answer after this rule. The last case is Luster versus the City of Lebanon, and this is a United States District Court case for the Southern District of Illinois. And the city filed documents that contained the Social Security number of the Lusters. And in that case, the United States District Court for the Southern District of Illinois said yes. We can sanction. They didn't sanction, actually. In the end, they entered a show cause order. Does everybody know what a show cause order are? They're really fun. It's like when somebody does something wrong and you want to hold them in contempt, you ask the court to hold them in contempt, and the court issues an order that makes them show cause why they should not be held in contempt. I love getting show cause orders against people. I've never had one against me, and I'm so glad. But it was close a few times. So anyway, a show cause order why they should not, and the court, was considering sanctioning these people. There was a local rule in this court that precluded the filings, and the Social Security number had been filed. I don't know how they were going to hold a city in contempt, though. That's the crazy thing I think about this case. But the court talked about civil contempt and quoted a long line of cases that say a court has inherent power to enforce compliance with its own orders and rules. And I think that's the law that that and these rules I think most courts would rely on now. What is the real risk here? I mean, we haven't seen big suits with big claims yet. I think you will be sanctioned if you file these court. You'll be held, ordered to pay attorney fees, I think. The sanction is really, or the risk is worse than that. We had a client recently who will remain nameless, who's a healthcare provider, and they filed proofs of claim all over the United States with their bills attached, and the bills had HIPAA information attached to it, all over the United States. Well, what did I say? It's ECF filing, right? PACER? Anybody in the world could go see what medical procedures these patients had had. So what did their lawyers, have to do? 200 proofs of claims in various jurisdictions. You can't take it back out of an electronic record. You have to get an order sealing it. We had to make a motion in every one of those bankruptcy courts and move the court to issue an order sealing the records. Now, was that costly? Absolutely. Did it have to be done? Absolutely. So that's the risk here.
So I'm Sarah Spurlock. I'm in our Louisville office. Along with Ian Ramsey, I am one of the leaders of our privacy and data security practice group, and I'm also a member of the firm's healthcare group. So I deal with these data and privacy security issues and HIPAA issues like Liz was just talking about quite often. So many of you in the room, or some of you in the room, may be like me. You can say that you hit the trifecta of data breaches in the last year. I got letters from Home Depot, Target, and Anthem. Unlike the wagering you can do this afternoon, that's not a trifecta you strive for. So I wanted to just kind of give you an overview of some of the data breach laws that may apply to you and your organizations. Right now in the United States, we do not have a comprehensive data breach law. There's nothing that applies to everyone in every sector in every circumstance. It's really a patchwork that is dependent on the sector that you're in and dependent on where you're doing business. In particular, one of the areas that you have to consider, where are the obligations for all these notifications and all these data breaches that have now become public and seemingly we're hearing about more and more monthly, weekly, even daily. Where does the obligation come for these organizations that are experiencing these breaches to make them public? And one source is state data breach laws. And for those of you doing business in Kentucky, just in 2014, Kentucky jumped on the bandwagon, so to speak, and we now have 2 new data breach laws. Prior to 2014, we didn't have any data breach law in Kentucky, so we join 46 other states and territories that now have a state-specific law that governs generally some sort of breach of personal information. And you can see the only states that are left without state-level data breach laws now are Alabama, New Mexico, and South Dakota. And I would bet, legislation may be coming in any one of those states. And there's also potential federal legislation that would give us a more comprehensive framework. But for now, we're left with this patchwork. So just briefly about Kentucky's 2 new laws. One, which is the one here on the left, I'll refer to as the agency law. It's more limited in its application because it applies primarily to state and local government agencies, also to public schools, public universities, but it only applies to non-agency entities to the extent that you as an organization have a contract for services with that agency and you receive personal information in performing services. So if that's the case, you're considered a non-affiliated third party and you may have obligations under this agency statute that we now have for data breach obligations. It just went into effect in January of this year, but the one that I'd like to focus on more, although you should be aware that there are 2 out there, the one I wanted to focus on more is the one you see there on the left. And this one applies generally to information holders, anyone doing business in the state of Kentucky, with some notable exceptions, which we'll talk about. And it applies to breaches of the security of the system, which is sort of a term of art that you see a lot in these various state laws. Notably, the KRS 365-732 only applies to information that is computerized. So it's not going to cover paper records. It's just computerized information. And it really is only triggered if you have computerized information in unredacted or unencrypted form. So under this sort of general data breach law, as we'll call it in Kentucky, again, an information holder is anyone that is doing business in Kentucky. However, there is an exemption for certain financial institutions. So while you need to be aware of it, it's possible, depending on the circumstances, that you're not actually going to have to be concerned with it. And I'll go into that in a little bit of detail in a minute. So the way these state laws are typically written, you always have to consider who's covered, what information is covered, what triggers an obligation to report a data breach, what's the timing. So in Kentucky, our general data breach law covers personal information defined as a name, which can either be first name and last name or just a first initial and last name, in combination with one element of sensitive data, which is either going to be a social security number, a driver's license number, or an account or credit or debit card number, along with the necessary PIN or credential to access that account information. So you have to have that combination to be even, within the realm of personal information that's going to trigger potentially obligations under the statute. So the good news for many of you in this room is our statute was written with a very broad exemption, and it's interesting because it actually says in KRS 365-732 that the provisions of this statute, along with the provisions relating to non-affiliated third parties that I mentioned in the other agency statute, which is a series of 4 statutes, they don't apply to any person who is subject to GrammL Bliley Act Title V. So that's going to be, if you're required to comply with GrammL Bliley safeguards rule, there's a carve-out from compliance for these 2 laws, either directly under this one or as a non-affiliated third party under the other one. So how that actually plays out, I think, is going to be a little bit interesting, and I'll give you an illustration of that in a moment. There's also a similar carve-out for anyone subject to HIPAA, and then for state agencies under this particular statute because they're covered by the other statute. So not to leave out those of you who have business in surrounding states, I wanted to highlight the same type of treatment you often see in other state data breach laws for financial institutions. So the one thing that you have to keep in mind, every data breach is not the same. You're going to have different facts and circumstances in every one, so you're always going to want to consider, is there something about this that is going to trigger an obligation under a state law that the one that we looked at 6 months ago did not? And the exemptions for financial institutions are not created equal among the states. So just to give you an example of that, in Ohio, you enjoy an exemption if you're a financial institution if you're required to notify under applicable federal law. So, if you're going to be giving a notice in connection with a data breach under the GrammL Bliley Act, then in Ohio, you wouldn't also have to notify under their statute. In Indiana, same thing. Notification is not required if you comply with GrammL Bliley. So you would actually have to be giving your notices under GrammL Bliley in order not to be covered by the Indiana law. In Tennessee and in Kentucky, as I mentioned, the statute just says there's an exemption if you're subject to GrammL Bliley. So to give you an example of how I've sort of thought this might play out, under the GrammL Bliley Act, which I'll talk about in just a minute, you have an obligation generally to report data breaches that relate to, some kind of unauthorized access or disclosure of non-public personal information relating to your customers. So let's say you're a financial institution, you have some kind of hacking incident, you're able to determine that it's isolated to a database that only has information about your employees, okay? And it includes, employees' names and social security numbers, but that's it. None of your customer information, none of your consumer information, just your own employees. So if you're in Ohio, you likely have to notify under Ohio law because there's no federal law that's going to require you to notify in connection with that breach related to the employee information. GLIBA is not going to apply there. If you're in Indiana, same thing. You're not going to be notifying under GLIBA, so the Indiana law is going to kick in. If you're in Tennessee or Kentucky, you are technically subject to GrammL Bliley Act. So do you never even have to analyze the statute? I don't think that was probably the intent with the legislatures in writing those laws. I think they're meant to be a gap filler for when no other notification is required, but that's not the way they've been written. And so it'll be interesting to see, how that plays out when these types of scenarios come up and in case law. In Florida, for example, regardless of whether you comply with GrammL Bliley, give notice, you still have to notify the state of Florida. You have to provide them with a copy of your notice. So they've sort of taken it a step further and say you have to prove to us that you've given some sort of notice. So you're probably going to be stuck one way or the other notifying if you're in Florida. So to contrast that, if you have a laptop that goes missing and it's got a list of, your borrowers along with phone numbers and social security numbers for those borrowers, you're going to be likely notifying under GrammL Bliley in all of those instances. So except for Florida, where you'd have to send a copy of that notice to the Department of Legal Affairs, you're not going to have other obligations under these other state laws. So that's why you always have to consider what information are we talking about, what context, and not just assume that one law is or isn't going to apply. So I'm sure you all are very familiar with GrammL Bliley. It's one of the primary security rules and safeguard rules that applies to financial institutions. And financial institutions, or anyone that does significant provision of products or financial services. So it includes banks, but it also includes tax preparers and check cashing services and underwriters and financial advisors. So it's sort of a broader framework of financial institutions than some people may think about. And I think Ian's going to go into some of the safeguards and those types of things. But as I mentioned, there is breach notification. There is a breach notification component to the GrammL Bliley Act, and that's the reason for the special treatment under many of the state laws, because the notion is you already have a federal regulator breathing down your neck for this. We're going to be satisfied that you're complying with that. But like I said, some of the states didn't quite get there in achieving that goal, in my opinion, Kentucky being one of them. So another federal law that has a possible data breach notification requirement that you should be aware of is HIPAA, and Liz mentioned this. I always like to mention this because I think a lot of financial institutions sort of start from the premise that HIPAA doesn't apply to us because there is a statutory exemption for financial institutions. However, the exemption only applies to financial institutions when you are doing certain types of things. So I've listed the things that are exempt. So if all you're doing is processing payment or clearing checks, those types of things, they're, what I sort of group into a category of traditional bank functions, then you would have an exemption from HIPAA requirements generally. But there are a number of services, and I think particularly as financial services have evolved and customer service has grown over the years, there's a number of services that do trigger HIPAA obligations, and people aren't necessarily aware of that. So it's important to know. The general idea is if you're receiving information from a healthcare provider, from an insurance plan that is in excess of the information that you would typically need to do to just process a payment or complete that one of those traditional banking functions, then you're likely going to spill over into the realm of a HIPAA business associate. And really all of the obligations relating to HIPAA, except some sort of privacy notice obligations, then apply to you and apply to that information. And likely you're getting requests to sign agreements to that effect from at that point, your commercial customers. Lockbox, I think, is the one that's most common because, at least the way it worked for the client that I was working with, they would get the check, they would clear the check, but then they would have the EOB or the remittance coupon, and they would be taking information from that, keying it in, putting it together in a report that the client would get. They were imaging all the documents, and then they were sending it out in batches to the clients so they could reconcile on their end. So there's no reason that a bank would typically need an EOB or a payment coupon unless they were providing that kind of value-added service of running those reports, doing that reconciliation. And so the Office for Civil Rights, which is in charge of HIPAA enforcement, has said, in that case, you, the bank, are a business associate, and all of the HIPAA obligations attached with respect to those patients or those insureds for those consumer customers that you have. So that's just something important to keep in mind, because I think a lot of times people just think, oh, there's an exemption, and you really have to look at the products and the services that you're providing and the nature of them and the type of information you're getting. And you may be surprised to find that you have a lot of HIPAA obligations that have gone, undetected. And HIPAA does have a very stringent breach notification rule as well, which is a big part for many of the Anthem notifications and things like that.
My name is Ian Ramsey. I am the co-chair of our Data and Privacy Security Group at Stites and Harbison. I'm also the chair of the firm's Information Security Committee, which means I get to wear two hats, dealing with clients' issues relating to data security, but also ensuring that our own security is in place and operational. I came to this, I think it was probably bred to be this. I am the son of a CIA operative, and so my childhood was a little bit different than others. I was very, very good at hide and seek as a young child. So, but I have this mixed view of the world. In one sense, I view things that people have the right to be private, right? That their information should be secure. But I have this innate knack of wanting information. I love information. I love to collect information. I love to see how other people collect information. I thought this was appropriate. I actually received this last night. Anybody a Hyatt member? Did you receive this notice?
I got mine too.
Yeah, sorry. This is great. This, I'm not sure what this is. And I put it up there because we deal with clients in terms of drafting notices. As Sarah said, when a breach occurs, you're supposed to notify the people that a breach has occurred. It's required by state law and in some instances by federal law, right? So I get this notice from Hyatt, and I'm looking at it, and it doesn't tell me that I've been hacked. It doesn't tell me anything about what happened other than somebody had unauthorized access using usernames and passwords. They want to make it very clear that Hyatt Gold Passport was not involved. They don't think in terms of it didn't come from them. But this, what I really think this is a combination of someone at Hyatt who was very astute on the marketing side in combination with someone who was doing the IT security. I would call this you're going to get another notice, right? It's something's going to come out in the media that's going to tell you something bad happened relating to Hyatt and your user accounts, and so I'm just waiting for that. So, but here's what happens with me, because I've gotten so many of these notices, I've seen so many of these notices, that this is what's happened to me. Rational inattention, and this is a phrase that was I just read it. The Wall Street Journal did an insert on Monday on cybersecurity, and this word jumped out to me because that's me in a sense, and I think that's a lot of you that are sitting out there, and more importantly, it's your employees. Rational inattention. So what happens is that you know that something bad might happen, right? You know that, for example, your password might get taken. You might get your credit card information taken. Something bad might happen. But what do you do to prevent it? Well, the writer of this article actually said nothing. Had the same password for 3 years. It's a combination of like his name and something else, real easy to figure out. He's had it for 3 years. He's done nothing. Absolutely nothing about it for 3 years. And it's not that he doesn't know something bad will happen. He knows something bad is going to happen. It's just that he's been inundated with the notices like we've gotten. And it's become this rationalization of, I'm just not going to pay attention. Maybe it'll just go away. Maybe we just don't have to worry about this anymore. But here's the reality. Your industry has changed. You know that. You know that better than anyone else. Your industry has changed. Before it used to be you had a bank, right? A bank was this vault. You had this perimeter. You had all this information stored inside your bank, right? And then as technology developed, you had your firewalls, right? The nice tech term, firewalls that protected your bank. You had all the information inside your bank, firewalls. Yeah, how porous are the financial institutions now? Mobile banking, online banking, all that. It's different. Everything has changed. You have information that's going back and forth between you and your clients on a regular basis, thousands of times per day. And the reason I bring that up is because right now, as I was sitting here this morning, I was actually answering emails for a client that does an online retail thing. They sell things and they collect credit card information. And they had a hack. And here's what they figured out. The hack actually came from the company that was hosting their website. A company that was, so the company was supposed to be protecting their data, that was hosting their website, that had all these things. An employee inside that company got their passwords at an administrative level, right? Went into their code, wrote wrote code in their script that at the moment the credit card information for the person was revealed in order to authorize the transaction. And it's talking about a millisecond. So the information comes in, it's encrypted on their website, but the millisecond that it was unencrypted in order to complete the transaction, they wrote code to grab that now unencrypted data, stick it in a chart somewhere else on the website that was ghosted, that was hidden. So that you had to, in order to see it, you actually had to go to the section of the code and do a screen print, and it would only reveal itself then. If you went over it with the mouse, you wouldn't see it. It was hidden. It was into it. So they found it. It had nothing to do with their security whatsoever, but what it had to do with is their security of the person who was supposed to be handling their security, right? So that's an issue for them. And those are the kind of issues that you're going to see. So let me talk really more at a high level relating to things. Let me first just, I thought these were funny. The Wall Street Journal article I thought was really, really interesting. Passwords, these are great. Yeah. Here's what I'm thinking for your industry, though. What about stopping your clients from using these passwords? Okay? I mean, these are the top 20. I've seen other lists. They kind of are all the same, but the one that jumped out to me, monkey. I don't know. I mean, monkey, everybody, that is one of the most known hack passwords. Monkey, okay, great. But you see these combinations. I know people who do worse than this. I know people who do their passwords first initial, last name. That's their password. First initial, last name. And I look at them and say, okay, I'm thinking of setting up a dating website between you and the Eastern Bloc hackers. So you can just find your hacker online, introduce yourself, exchange correspondence, because that's what's going to happen, all right? Let's just go ahead and do that now. But here's, all right, so for those of you who are romantic, and I thought this was really nice. Years ago, there was a hack. And it actually was a person who it wasn't for bad reasons. He wanted to demonstrate that companies just did not have secure passwords. And so he went in and he grabbed something like 30 million passwords off of a website, off a huge company, 30 million. He didn't use them for anything. And he didn't have any other identifying information other than passwords. And he published those on the web. So a university grabbed all those passwords and has been doing data study on it for years. And here's the good news. It's the good part of all of us. By a majority vote, the most used passwords has the word love in it. Somewhere in it, love something. They love a pet, they love their husband, wife, whatever it is, but the word love appears in it. Here's another thing. If you think you're being cute by putting a date, like you put your name and then you put the year 2015, and then let's say you want to really be cute, you want to put an exclamation point after the end of it, yeah, don't do that. Hackers look for that. Exclamation point, by the way, it's not on this list, but lots of people think they're being smart by putting exclamation point. Don't do that. Don't put a year of when something happened, unless it's so far in the past that it's just unrelated in every way. Don't do that. Because another thing that hackers do is called social engineering. They go to your Facebook pages, they figure out who you are, who your family are, who your pets are, and guess what? They put them in algorithms and they run them against you, against everybody. They're building a database, and that's what they're trying to do, is to hack into your stuff. So the next slide I thought was interesting. This is your IT person talking to you. I don't know if there's any IT people in the room, but the concerns of your IT people, this is what they're telling you. This is stunning. Only 51% conduct security awareness training. Half. security awareness training. If you don't have security awareness training, please do. Just, it's basic, okay? Beyond telling your employees they can't have those passwords, and I'm happy to send this list to you, tell your employees they can't do this. And then figure out a way whether or not you can stop your clients, your customers actually from using these, because that creates problems for them, and then it creates problems for you too. But in terms of the IT people, they're not complaining as much about funding. 37% say I don't have enough money to do what I want to do. What that tells me is, in fact, the industry, and really specific, your industry is kind of getting it. The reason I say that is I have someone over at Marsh Risk Management, and they gave me some information that says in 2013 to 2014, 17% of the sector, of the financial sector, got cybersecurity insurance, right? 17%. You might think that's a lot. 43% in the healthcare sector. So that tells me either A, the people in the financial sector, you guys are still asleep, you don't get it, or B, you do get it. I kind of think you get it, and the reason I think so is because you're so heavily regulated already, right? So you get it. Now, I'm going to skip through these because these are just cases. These are FTC cases. I want to go to the last slide. Let me just talk about big picture here, okay? So I was curious about what the Federal Reserve has to say about cybersecurity, right? So December 5th, 2014, the Advisory Council minutes were published for their meeting. And here's the good news. They think as a whole the financial industry is doing a good job, and in fact gave compliments to the industry as a whole in terms of all of the things that you're doing to protect your customers' information, right? That's great, makes everybody feel good. But what I went to is the needs improvement part of the minutes, of the recommendations, and two things jumped out to me that you might want to pay attention to. One is that the Reserve wants to have 100% compliance of all financial institutions sharing information with the Financial Services Information Sharing and Analysis Center. So when you have a breach, when something happens, they want to make sure that information is going to the center, so that that information is shared across the industry, so that when something happens at one bank, right, or one financial center, everybody's aware of it and can get ahead of it before it becomes an epidemic across all lines, okay? The other thing which I thought was really interesting, and some of you may have heard of this, the Target case where Target got sued because of their breaches by the financial institutions. Well, that recommendation, there's a recommendation in the minutes to say this. It says that the Reserve says they want to require that other companies or industries responsible for breaches reimburse financial institutions for their expenditures in full, right? And they're hoping to incentivize the other sectors to beef up their security. That's what they want to do. And as I said, if you don't know about the Target case, that's what's going on in the Target case, where they got sued because of all their breaches and the losses that the financial institutions ate. They're going after Target and saying, not my fault, it's your fault. You need to pay for these things. The other thing that's going on is in terms of the CFPB and the FTC, it's the most recent case. And I don't have that up there. These are just my notes that I was quickly jotting down because, again, flexibility is the key. But so it's a case called Bayview Solutions. I don't know if any are you familiar with it, but this is interesting. It was a debt seller, right? So it's someone who's buying up debt and then selling it. And what they went wrong is that they had a public sale of all this debt online. And anyone who wanted to participate had to get a password and type it in, and so they could go into the website to see what was for sale, basically, what they could get. And that's great, except that none of it was encrypted. And so over 500 unauthorized users gained access to over 70,000 records of individuals that contained their names, social security numbers, credit card information, banking information, you name it, they got it. And so that's the most current FTC case that's out there at the moment. Now, in terms of your industry as a whole, there is the most current press release that I found. March 30th, 2015. It was actually issued by the Federal Financial Institutions Examination Council, and it is on malware. So if you haven't seen it, go to that website, take a look at it. I'm sure you're familiar with them. They have a tendency to produce very large books that tell you everything you want to know about cybersecurity. I do think, as being in the sector, I do think that you're going to see more, and here's why. I know that there is a cybersecurity and critical information or infrastructure working group that is under the Federal Financial Institutions Examination Council, and their goal is to work on the federal and state level to create regulations concerning, or to create recommendations concerning cybersecurity. The White House issued a white paper recently on cybersecurity. The FTC issued one as well. It's going to be a growing issue for everyone. It's going to be common. And you have to ask yourself some very basic questions. What are you going to do? What are you going to do as an institution to deal with your concerns of your clients in terms of their security with the demands? And that's what I really think about it. Think about all the people in the financial institutions that you do business with. They want everything now, right? They want instant access to their accounts. They want their money now. They want to be able to move money around. They want all of those things now, right? But when something goes wrong, who do you think they're picking up the phone and calling? They're calling you. And so it's this pressure about you're trying to give your customers what they want, but equally you need to think about what it is you need to do to protect yourself. And so this last slide really is about that last part. What it is that you need to do in terms of your institutions. My guess is you have all of this in place, I would hope. If you don't, I'd be happy to talk to you. But you have your policies, procedures, training, vendor management. Those are the agreements to verify that, in fact, the people who are doing business for you actually are secure in the way that you anticipate they're going to be secure. Technology audits. Do you know what your system is capable of doing? Where the holes might be? Are you paying a third party to, for example, to test your employees? Are they following the policies and procedures or not? And then the investment. Because I've heard this. We did that update 5 years ago. Okay, so every Tuesday, updates come out. You may have heard this. Every Tuesday, updates on software come out. There's a press release that exists. And so every Tuesday, it's called Update Tuesday, and it tells you where all of the gaps in software need to be fixed. But guess what? It's actually a shopping list for hackers, because it announces to them the following updates need to be uploaded to your software, and the hackers read and say, great, that means there is a glitch in that software that I can expose for myself to do whatever I want. And the reality is that a lot of companies don't update. They wait. And they wait for a variety of reasons. They don't have IT people that are internal to them, so they have to connect with a third party to do the update. It costs money, it's time, and so they don't do the updates. And what happens is it causes problems. Home Depot, mm-hmm. What was it running? Windows?
Something old.
2005 or something like that? It was running, that's what it was running. That's why that was part of the reason. Their software was so outdated, they did not update it, and it led to their problem. So continual investment is important. You have to invest in technology. It's part of it's doing business now. It should be in your budgets. You should be talking to your IT people. If you don't have an IT person, you should find someone that you trust. Listen to them. You just have to think about it. It's not once every 5 years. It's maybe once every year, maybe once every half year. I mean, it's that quickly. It's evolving. Insurance. I talked about that a little bit. There is cyber security insurance. It's new. It's new. I don't even know how they're selling it to your industry at this moment. I've talked to a couple people in the industry. There's a lot of different policies out there. Sometimes it's attached to your commercial policy as a rider. Sometimes it's an independent policy. You need to look at it. You need to make sure that you're getting what you think you're getting, because sometimes you might not be, so you have to read it closely. Incident response, and I put this up here again because of my experiences with the clients, is they don't have an incident response team at all. they pick up the phone and say, I have been hacked, and they don't have people in place to be able to respond to it. Things happen, it used to be, what was it? The rule was, make sure you call everybody by the next day, right? These things happen in hours. I mean, it gets out of hand so quickly that you have to have a team in place, ready to move immediately when something happens. And notice the people that I have on the team. So I have the CEO, CO, General Counsel, IT, HR, and your marketing people. Then you've got your external IT people, because depending on the breach, you're going to need to bring someone in to help you understand exactly what happened and then fix it. Fix it is the important part. Then, of course, lawyers. Lawyers need to tell you, well, you should have done that, right? And then the media specialists, because it really is becoming a race to the internet now and controlling the message of what happened, right? The notices have to go out. You know that. The notices have to go out in many of these instances. So, you have to control the message of what happened. But in order to know what happened, you have to have your team together and moving very quickly to figure out exactly what happened and why did it happen. Now, the reason I put HR in there, for two reasons. One is that your HR people, in fact, are the people who are probably answering a lot of these questions. IT people are probably hard to find sometimes. They're moving around from here to here to here. If you have them, your HR person probably is the person that most of your employees is going to. They're talking to them. Something happened, I was on the computer, and they don't want to go to the IT person, because the IT person immediately say, are you kidding me? You clicked on the kitten? Give me a break, right? So talking to the HR person. Now, so your HR person is someone who needs to be educated but part of the team, but also your HR person needs to be part of the team, because you may have to take actions against the employees who were involved. And I say that because how many times can you say to the person, don't click on the kitten picture, please don't do that, and they do it anyhow. And now as a company, you need to take action against that employee. I know that sounds extreme, but here's why. If you don't and it happens again, fair warning, because now you have a policy that you're not enforcing. So you're forced to take these actions, and that's why I include the HR in there.